All right. Also tonight, an exclusive report from John Solomon surrounding the president's power to declassify documents. He is the editor-in-chief of justthenews.com. John Solomon, tell us what you found.
Yeah, listen, there is a court ruling from a decade ago this year that is going to have significant impact on the legal battles that are going to ensue over this raid. And I never thought when you woke up this morning, we'd be talking about Bill Clinton's sock drawer, Melania's closet, Melania Trump's closet, and Donald Trump's raid. But that's what this ties together. In 2012, a court ruled that records, audio tapes that Bill Clinton had put in his sock drawer at the White House of hours of conversation with a famous historian about contemporaneous events in the presidency were personal records, and that there was no legal medium by which an outside person could come in and challenge it. Basically, what the court ruled, Judge Amy Berman Jackson ruled that the president's decision of what constitutes a personal versus a government record is solely in the discretion of the president himself. There is no enforcement mechanism. The courts can't get involved. And here's another important thing. If the National Archives wants to go get it, they can't raid the president. They have to follow a civil procedure. So think about that. We just raided the FBI just raided Donald Trump's home to get presidential records back for a law that says it's only a civil remedy.
This is going to get more interesting. Great reporting, John Solomon. We'll follow this closely. Keep us up to speed. Thank you, sir. All right, straight ahead, the great one, Mark Levin. He'll give us his take on last week's FBI raid at Mar-a-Lago. He's pretty fired up. Straight ahead. All right, tonight, even more new developments on the raid at Mar-a-Lago, as we're now learning that former White House counsel Pat Cipollone, and by the way, his own deputy, were interviewed by the FBI about boxes of classified information shortly after Donald Trump left office. And tomorrow, by the way, a hearing is scheduled in federal court on whether to unseal the Mar-a-Lago search affidavit. The DOJ does not want that to happen. Here with reaction, he is the host of the #1 show weekends here on the Fox News Channel, Life, Liberty, Levin. Also host of his own nationally syndicated radio show. I call him the great one. All right. Why doesn't the DOJ want that affidavit unsealed? And isn't there something called executive privilege? Wouldn't the president have the right to exert executive privilege for his White House counsel and his deputy White House counsel?
Well, first of all, why should they release them when they're leaking it in bits and pieces? And if I were the movements in this case, I'd be bringing all these articles where unnamed sources are leaking information about the affidavit. I want to get to something here. First of all, I have a question. Did Bill Clinton, George W. Bush, Barack Obama, Dick Cheney, Al Gore, Biden as vice president, did they remove any papers? Did they remove any? Do we know if they removed any papers? Do we know if they removed any classified papers? And how do we know? Were their homes searched? Did they get subpoenas? Were there search warrants? The answer is we don't have the foggiest idea. Now, let's go to the Constitution, because I want to try and educate the Attorney General of the United States. Article 2, Section 1, the executive power shall be vested in a president of the United States. This is why the president can classify and declassify at will. He doesn't answer to the FBI, Department of Justice, or some bureaucrat with a regulation who says, no, he can't declassify till he fills out this paperwork and hits all the boxes. He's the executive branch. That's why the 1917 Espionage Act cannot be used against a sitting president. If he can declassify and classify at will, and do so as the head of the executive branch, he can't be held criminally liable for taking documents with him, even classified documents. Why? Because if he can declassify them at will, he can take them at will. But if I'm wrong, then I have a question. If I'm wrong, because the law itself, the Espionage Act, people ought to actually try and read it rather than read what the press says about it. Here's the section. Listen to this really carefully. Whoever being entrusted, I'm reading a relevant part, whoever being entrusted of any document relating to the national defense through gross negligence, remember Hillary, permits the same to be removed from its proper place of custody shall be punished, and so forth and so on. If Trump is, and he's not, but if Trump is guilty because he has classified information, everyone along the chain of custody is guilty. Every single person. That's how absurd this is. Why? because from the person who created the document, that handed it to somebody else, that brought it to the Oval Office, who removed it or failed to remove it, and so forth and so on, they violated Part E of Section 1 of the Espionage Act. Whoever being entrusted, you have an obligation to secure it and bring it back to its proper place of custody. Well, they failed to do that, didn't they? So the Espionage Act does not apply to a president, regardless of what these federal prosecutors are trying to concoct. But there's more. Let's take a look at the warrant. The warrant is extremely broad. Any physical documents with classification markings, along with any containers, including any other contents, in which such documents are located, as well as any other containers and boxes that are collectively stored or found together with aforementioned documents and container box. That's everything. Everything. Then go to the next part. Any government and or presidential records created between January 20, 2017 and January 20, 2021. You could go online right now and buy a signed letter by a president to a constituent or somebody on White House stationery. This presumably would include that. But this is unconstitutional. This warrant is unconstitutional. And I don't care if a master signed off on it or not. That doesn't make him Solomon, and I'll tell you why. We have what's called the Fourth Amendment in America. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly, the word, particularly describing the place to be searched and the persons or things to be seized. No general warrants. The colonists opposed general warrants. They suffered from them from the Crown, where they'd say, we're searching your home. Here's a general warrant or writ of administration. We're going to go through your stuff, but what are you looking for? We don't have to tell you. We're going to go through your person, but we don't have to tell you. The Fourth Amendment is supposed to prevent that. This language, in and of itself, in this warrant, violates the Fourth Amendment of the Constitution. And there's a leak in Newsweek tonight where we have so-called two intelligence officers, because the government's trying to get its message out, and they're telling different stories. They said they wanted as broad of investigation as possible to grab as much paper as they could. There it is. There's the case in front of the judge tomorrow. The government's leaking. This warrant that you issued was unconstitutional. The American people have a right to see everything. This is not supposed to be done to a former president of the United States. This is unprecedented, and not because it's Donald Trump, but because it is Merrick Garland, Matthew Graves as the U.S. attorney, and a cabal of Stalinist leftists at the Department of Justice that will stop at nothing to destroy this country. That's it. I'm done.
The great one, Mark Levin. Let's see if people are listening to you. Anyway, don't forget Life, Liberty, and Levin every weeknight, every Sunday night at 8 p.m. right here on the Fox News Channel.